Welcome. In this session, we are going to have a look at accounts of various types of customers such as individuals, partnership, companies, HUF, illiterate persons, minors, accounts of trust, executors, etc. We are going to learn about what are the minimum precautions the banker is required to take when we open this type of accounts. Accounts of individual, that is single account, its name in the name of an individual, normally operated by the account holder himself. However, the account holder can authorize somebody by giving a mandate or a power of attorney. In order to avoid legal complications that may arise after the death of the account holder, the banker should suggest such account holders to open a joint account or at least give a nomination. So this is the sort of an education which the banker should cultivate and educate the customers for opening a joint account. The accounts of joint accounts, in case of individuals, it can be opened in the name of more than one individual, and for convenience of operations and also to avoid legal complications, it's always better to have proper operational instructions. How the account is going to be obtained, how the money is going to be repaid in the event of death of the one or more joint account holders, clear-cut, unambiguous instructions should be obtained by the banker when you open a joint account of individuals. The mode of operation of joint account can be altered only with the consent of all the joint account holders. Say for example, if there are 3 joint account holders, one of them comes and says that the operational instructions are to be changed, the banker cannot act upon such instructions because there is no consent of the remaining 2. Instructions regarding operations in a joint account can take any one of the following forms, that is, if there are 2, it can be either or survivor. If there are 2 account holders, it can be jointly by both of them or survivor. And if there are more than 2, it can be anyone, 2 or more, any one of us, payable to the last survivor. So this unambiguous and clear-cut instructions should be obtained by the banker. In case of 2 account holders, joint account holders, the instruction can also be former or survivor. That means the first account holder is supposed to operate and get the money. Unless the first one expires, the second one cannot operate the account. In case of more than 2, say for example A, B and C, the instruction can be former or survivors. So till A is alive, B and C will not operate. The former only, the money will be payable only to the former, and former has authorization to operate the account. I had mentioned about obtaining nominations in case of individual accounts. It can be obtained even in case of joint accounts. Also, what are the rules pertaining to nomination? Sections 45 ZA to 45 ZF of the Banking Laws Amendment Act 1983 provide rules for nomination facilities to bank customers in respect of deposit accounts, safe custody accounts and safe deposit vault locker accounts. The rules stipulate that nominations shall be made only in favor of individuals, which means that you cannot nominate an association, a trust or a society or any organization in their official capacity. So only individuals can be nominated. There cannot be more than one nominee in respect of joint deposit accounts. So this is also one of the important aspects which a banker should remember. In case of nomination for safe deposit lockers or safe custody articles, this facility is available only in case of individual depositors, not in respect of persons who are jointly depositing the articles for safe custody. Unless the customers prefer not to nominate, This may be recorded without giving scope for conjuncture of non-compliance. A nomination should be a rule to cover all other existing and new accounts. So, as far as possible, nomination should be obtained. Now, let us have a look at the sole proprietary concern account. The sole proprietorship concerns account is an account in the name of the firm or a business owned by one individual who is its proprietor. It is in all other respect an account of an individual in his single name, except that it is operated upon by the individual in his capacity as proprietor on behalf of the firm or in the name of the firm. That's not the only difference in this case. Now, bankers also open accounts in the name of partnership firm. It can be two or more persons who have come together for carrying on a business, so they can open a partnership account. The number of partners in a partnership firm shall not exceed 10 if it transacts the business of banking and 20 if it transacts any other business. So, while opening the partnership account, this aspect needs to be kept in mind as to how many partners are there in this partnership account which is going to be opened with the bank. So, if it is more than that, it becomes an illegal association in terms of section 11 of the Companies Act. One more important thing which a banker must remember is HUF cannot be a partner in the firm, and hence firms who have HUF as partners may be viewed as not competent to enter into a contract. So, the banks must ensure caution while dealing with such firms who have HUF as partners while opening the accounts in the name of partnership concerns. We are also required to open many times the accounts of Hindu undivided family. In this case, Karta or manager of a joint Hindu family has the necessary powers to open and operate an account of Hindu undivided family. The banker, of course, obtains an HUF letter signed by all the members of the family incorporating such a right to the Karta or the manager so that he can operate the account. Then operations on the account by the partners. Operations on the account of the firm are governed by the instructions given by all partners recorded in the account opening form. The modes can be jointly by any two, all of the partners, jointly by two or three, singly by one of the partners. So, it all depends on the convenience and the requirement of the partnership concern. The bankers also open accounts of illiterate persons. Here, it is necessary that proper precautions are taken, because the banker may come to grief if someone operates the account. So, the precautions which need to be taken in case of illiterate persons accounts is obtain a passport size photograph. Of course, this is compulsory for most of the accounts and all the accounts for that matter. Thereupon, the thumb impression mark should be obtained on the account opening form in the presence of the bank official, and this thumb impression marks affixed by illiterate persons on instruments or equivalent to their signature. So, while allowing the operations of the account, the illiterate person has to come in person along with the passbook, put his thumb impression on the withdrawal slip before the bank official, and then permissions for withdrawal are permitted. There are occasions to open accounts of visually impaired persons. So, banks were a little hesitant. The person cannot see. How is he going to operate the account? But in a recent case, case number 2791/2003, the Honorable Court of Chief Commissioner for Persons with Disabilities, he passed an order on September 5th, 2005, and has instructed the banks that the bankers should offer all banking facilities, including issuance of a checkbook, ATM facility, locker facility to the visually challenged persons and assist them in withdrawal of cash. So it becomes important for the banker to open an account and also help the visually impaired person for withdrawing the amount. Whether an account of a minor can be opened, that's a question which always comes to the minds of the bankers. The question comes because of the Indian Contract Act, which says that a person is capable of entering into a contract if he is a person of full age, sound mind, and is not an undischarged insolvent. A person is said to be of full age when he has attained the age of 18 years. But the banker can open an account in the name of minor. At times, self-operating accounts also can be opened by the minors as per the rules. Different banks have got different rules of what age a self-operative minor account can be opened. What is important in this case is, generally the banker opens an account of the minor which is to be operated upon by the natural guardian, father or mother. So different rules are there in different banks for allowing the operation of the account in respect of self-operated accounts. When I said the account to be operated by the natural guardian, again here the different acts come into the play. Say for example a Hindu minor, the law provides that the natural guardian of a Hindu minor is father. In case of a boy or an unmarried girl, the father, and after him the mother, provided that the custody of the minor who has not completed the age of 5 years shall be orderly be with the mother. Now in case of illegitimate boy or an illegitimate unmarried girl, the mother will be the natural guardian and after her the father. And in case of married girl, the husband will be the natural guardian. So one has to be familiar with the law of the land and open an account. In case of Muslim law, it is only the father who can be the natural guardian. Several banks were opposing that the account in the name of minor with mothers as guardians cannot be opened. This is because Section 6 of the Hindu Minority and Guardianship Act, which stipulates that the father alone should be deemed to be the guardian in all such cases. Notwithstanding this legal provision, the Reserve Bank of India has clarified that accounts can be opened with mother as a natural guardian, provided they take adequate safeguards in allowing the operations. What are the precautions which are required to be taken with the banker in such cases? Number one, minor's account, whether it is a fixed account or a savings account with mother as guardian to be opened, the minor's accounts opened with mother as guardian are not allowed to be overdrawn and they are always in credit. So once you are able to take these precautions, the accounts in the name of minors with mother as natural guardian can be opened. It's quite common for the bankers to open accounts of limited companies. Now before opening the account of limited company, what are the requirements which are required to be complied with? Number one, the original certificate of incorporation should be inspected and a copy thereof should be taken on bank's record. The original certificate of commencement of business should be obtained in case of public company. Copy of memorandum and articles of association should be obtained. Copy of the board resolution authorizing opening of the account in a particular bank, duly certified by the chairman of the meeting at which the resolution is passed, should also be obtained. A list of present directors signed by the chairman should be obtained. A copy of the latest audited balance sheet and profit and loss account in case of public limited company should also be obtained. After obtaining all these documents, what is most important for a banker is who is going to operate the account. So their details, their signature should be obtained in the account opening form. The bankers are also required to open accounts of trust. So before opening the accounts of trust, the banker should scrutinize the original trust deed. He should examine it. Satisfied that there are no onerous clauses. If the trust is a public charitable trust, enquiries must be made whether it is registered with the charity commissioner or any other competent authority. The trust should have minimum number of trustees as provided in the instrument itself, and that is why we say that we are examining the trust deed from this point of view. The operation of the account by only one of the several trustees can be permitted only if the instrument specifically provides in clear-cut terms about the operations of the account. So this is another point which needs to be examined by the banker while opening the account of the trust and studying the trust deed. Apart from this, the banker should also obtain a resolution signed by all the trustees, whatever be the mode of operation, whether it is going to be operated by 1 or 2 or 3, the resolution must be signed by all the trustees, and only thereafter the account of the trust can be opened. Many times we are also required to open accounts of executors and administrators. So this is basically in case of the managing the estate of a deceased person, and executor or an administrator is his legal representative for all purposes, and all the property of the deceased vests in the executor or administrator. So in this case, before opening the account, the banker should obtain probate or letter of administration before opening the account in the name of the executor and administrator. The accounts, such accounts should be opened in the style called as A, B and C executors in bracket, or we can call it as administrator of Mr. D who has expired. So this is the mode by which the accounts are opened. Let us also try to understand what is the rate of interest which is being paid on the savings bank accounts nowadays. Earlier, the Reserve Bank of India used to stipulate and inform all the banks that this is the rate of interest which is to be paid on savings bank account. And that was common for all the banks. Now the Reserve Bank of India, by its notification dated 25th October 2011, have made it free. Each bank can decide the rate of interest on their own. And this is applicable for resident Indians subject to 2 conditions. The 2 conditions which need to be satisfied as per the notification issued by Reserve Bank of India is: 1, to offer uniform interest rate on saving bank deposits up to rupees 1 lakh. So if a bank declares that the rate of interest on saving bank is 4%, that will be applicable uniformly to all those accounts where the deposit amount in a savings bank is up to 1 lakh of rupees. And if the balance is over 1 lakh, the bank can provide differential rate of interest if it chooses, subject to the condition that the bank will not discriminate on interest rate paid on such deposits between one deposit and another of a similar amount accepted on the same date at any of its offices, any of its branches. So these 2 conditions are required to be satisfied, because the authority is now given to the banks by the Reserve Bank of India. So this is called as deregulation of saving bank deposit interest rate. Thank you very much.